How long in advance is it?
Please be seated. Okay. There you are. Okay, make appearances for the record, please.
My name is Dr. James Eric McDonough. Your Honor, I'm proceeding pro se as the plaintiff.
Good afternoon, Your Honor. My name is Matthew Mandel from the law firm West Rhoda Healthman. On behalf of the defendants, Eric Stetton, Sam Zeskine, City of Homestead, and my firm, West Rhoda, actually it's West Rhoda Healthman, Colon Beerman. It's also named here. Thank you.
Okay, this hearing was scheduled because of a request for an immediate hearing over public records request as of, which was filed under case 17-17515 in Division 30. Judge Lindsay, who was previously assigned to Division 30, was elevated to the 3rd District, so it's vacant right now, and so I'm covering in an attempt to make sure that matters get heard. So I had the opportunity to look at the complaint. Along with that, on my desk this morning, I received Stetton, Zeskine, and Weiss-Sorota's motion to dismiss. I'm going to set that aside for the moment. I do need to make sure, 1 second, that I know Dr. who is at issue right now. So, of the defendants, City of Homestead has been served, right?
Yes, ma'am.
Okay, how about Stetton, Zeskine, and Weiss-Sorota?
Weiss-Rhoda has been served, Your Honor, but Stetton and Zeskine have not yet been served.
Okay. All right, so I've got service on City of Homestead and service on Weiss-Sorota. All right, so I know because I read the paperwork, we have this other lawsuit that is not consolidated with this case, but is indirectly related to this case that involves a City of Homestead off-duty officer that you have litigation with. So for purposes of our discussion, I just want everybody to make sure if you're referring to the other case, refer to the other case by proper name or by case number so that for purposes of the record, I'm sorry, so for purposes of the record, we don't confuse the record with regard to what case is being referred to at what point in time. Doctor, have you received any records pursuant to your records request yet?
Your Honor, this Friday evening, I received an email from the clerk saying that they had some of the records available for me to inspect at the clerk's office. So that would cover one of the refusals. And they also said they had a CD of other records in a separate records request, but it's not related. Okay.
And counsel, did you bring those records with you, or how do we test?
Yes, Your Honor. The records pursuant to his June 2017 request, we have actually the city clerk here. We have them here. We made them available, and we also have them available here as well.
Your Honor, if I may, I'm not asking for an in-camera inspection here. I think it's very clear and straightforward. I'm just asking to determine if I have a right to personally inspect records.
What's your response?
Well, as you saw from the complaint, Dr. McDonough has over time has given over 100 public records requests by his own admission. But the complaint really focuses on 3 requests from June of 2016, November 2016, and June of 2017.
Yeah.
All of the records have been produced. It relates to June 2016.
So wait, let me back you up there.
Yes, ma'am.
All the records have been produced, or all the records that the defendant believes should be produced have been produced, because there are issues in connection with privilege, I believe, that was raised of some kind.
Not not for these 3 subject requests, Your Honor. So the answer to your question is all the documents either have been produced or are being made available for him to review. This is the June 2017. Just so when you go through the complaint, it's based on the...
So June of 2017, and these are my notes, so I'm paraphrasing, was, have a seat everybody, was billing in the defamation case thing, not sure about that one. Was that the 2016?
Nope.
Okay, I've got contract and statute documents supporting his system, Merguido's acting in an official capacity, the Homestead criminal investigation, the Facebook pages of the Homestead Police Department, City of Homestead, and Mayor Porter, bar complaints and discipline, the total bill of the Homestead for 5 years, and the personal inspection. Oh, sorry, I can't read my writing. The issue of a personal inspection in the cameras. So I think, Doctor, what you want to know is whether you have a right to personally inspect the originals or personally, or what do you want?
My understanding of Florida Statute Chapter 119.07, allows for the, I'm sorry, let me make sure I get the right statute here. I don't want to misquote this.
No, that's okay.
Yes, Your Honor. Florida Statute Chapter 119.071A requires that whosoever has possession of a public record shall allow any person to inspect that public record at any reasonable time.
Okay. That tells me what the statute says, but what I'm trying to figure out is, what do you want from this court today? They're saying that the clerk is here and that they brought the records. Do you want to go look at the records at Homestead? Do you want to look at them here in the courthouse? What do you want?
Your Honor, we're focused on 3 specific requests, but there's approximately a dozen requests I filed to inspect records. In every request, I've been denied the ability to personally inspect the records in the location where the records are at, as required by law. And I want to make sure that in the future, when I ask to inspect records as a citizen and as a journalist, I have access to personally inspect the records of those who they're in possession of, with the city and with the law firm. The law firm is taking tax dollars, so in that effect, they're an agency or a public official, and I think that I have a right to access and inspect their records as well. That's why I lean the law firm, Your Honor.
Okay, so I am not permitted to give what's called advisory opinions, right? So I can't tell you going forward on your next public records request what the situation will be on that. The law says what the law says. Judges rule on violations of the law. The statutes tell you what you're supposed to do. So with regard to this case right now on these requests, and let me just ask you, is what you have here only on the June, sorry, I've got
2017.
Yes, so what about the prior?
The prior stuff has been produced as well, Your Honor, and there's no dispute. In June 2016, we've produced, we have copies of everything that's been produced in June 2016. November 2016, those records have been produced. And Dr.
And so now we're at June, hang on,
Right.
now we're at June 2017.
Right.
So what you're here telling me is everything's been produced. And by being produced, you send him copies, or you send him a disc, or what?
He has records for June of 2016.
Counsel,
Excuse me?
I'm asking you whether you sent him the copies, or whether he has been given access to sit there and look at them.
He's been sent the records.
That's what I mean. Did you send him hard copy or disc, or both?
How were they sent?
Both.
Both, as I understand.
Your Honor, if I may interject, these records, I was provided an email saying they were available. They have not been produced to me yet, and this was not produced until after the filing of the complaint, which is several months after the filing of the initial lawsuit, or the initial request, excuse me. Further, in one of the refusals where I asked for records of Public Information Officer Zachary Good, in that issue, he had, the media was doing a story of me being unlawfully trespassed from City Hall, and the media contacted the PIO asking for the city's position.
Mr. Good.
Mr. Good. In that email, Mr. Good responded back to Channel 7 and he had the email with several paragraphs. There was one statement in the middle of that paragraph that was in quotation marks. It falsely alleged that I had sued 11 police departments and officers. He had other false statements made against me and another gentleman, and I wanted to see where that statement came from, and they gave me these records that they say are allegedly responsive to that request, but the records they provided me did not go to the heart of the issue, and they've allowed me to, they forbid me from personally inspecting or to find out where that statement came from.
Okay, so if I'm trying to get to the bottom of what issues are currently pending, we have one issue in that you don't want copies, you want to personally inspect the documents, right?
Yes, ma'am, Your
So
Honor.
that's issue number one. Issue number two is, you're saying he's got everything, right?
Yeah, sure. Right. The issue is, it's not that he just wants to inspect it. He actually wants more than that. He wants more than what the statute provides. What he actually wants to do is he wants to go to the city of Homestead, sit down at Mr. Good's computer and go through his computer. He wants to go to Weiss Sorota's office and go and access our network. That's what he wants. It's not that he hasn't been provided the documents. It's not that he hasn't provided an opportunity to come look at the documents at the city of Homestead and to provide the way we provide them in the normal course of how we produce public records by the records custodians, the city clerk. He actually wants to go, he wants more than that. And there's no authority that Dr. McDonough has that will allow him to do that. So that's really the issue.
This, you know what this means, right? That means stop talking, okay? So, Doctor, in terms of being able to inspect records where the records are ordinarily held, the statute says what the statute says. It becomes a much less clear parameter, for lack of a better word, when we're talking about accessing people's hard drives and computers and actually sitting down at their computer. Is that what you're after?
Your Honor, the case law and the statute.
Sir, this is a yes or no question. I'm not trying to cut you off, but
Yes,
I need to figure out.
Yes, ma'am. I would like to personally inspect those records.
Okay, well, sir, the records is printed out by the records. Are you saying you personally want to get on the computers?
I understand that there are many reasonable restrictions that can be placed upon this, such as me being supervised and me not having access to many things or access to exempt or confidential information, Your Honor. But the statute is very clear that I'm allowed to inspect the records and that the records have to be provided in the form they're in. So if they have them electronically, they would have to allow me access to see the records electronically, not just in a paper form.
Okay, so what we can do there, because we do this all the time in private lawsuits, is we have them download the data, we include the metadata, and they give you that information. That's different than saying you get to get on their computer, because I don't think that that's what the public records requirement contemplates. For a number of different reasons, logically in that governments need to be able to function. And if you're sitting on somebody's computer, they're not on their computer, and therefore they can't do their work while you're using their hardware. So to the extent, and I can certainly understand wanting to see the electronic information in the background, the metadata, as we all know it's called. So with regard to that, I have no problem clarifying that. Now, in terms of inspecting copies or documents that are maintained institute in hard copy, do we have an issue with that? I mean, listen, it's obvious to me that the relationship between Homestead and Dr. Do you pronounce it McDonough?
McDonough, yes, ma'am, Your Honor.
McDonough is, you know, not warm and fuzzy. So he just gets treated like everybody else. And so what are the issues for which you have concern? I'll get to the law firm in a minute. But in terms of, you know, I know there was an issue about bringing cameras and all those sorts of things. Do I need to address those? Hang on, I'm coming back to you. Hang on. Go ahead.
Oh, the main issue, Your Honor, is looking at computers, looking at metadata or whatnot. There are documents, just because there's information on a certain employee's computer does not necessarily mean it's a public record. There's case law that, again, it has to deal with city business. So as long as we can ensure that whatever he has access to is in fact a public record.
Well, I'm asking you to create the database, just like we create databases all the time in construction cases or otherwise.
It's not a problem to do it.
Right.
If he wants the emails in the electronic format, we can provide that. That's not a problem.
Okay.
That's not a problem.
And that's reigned over the land.
And that's,
it just doesn't seem like it should be this simple, given the amount of litigation back and forth.
Well, Your Honor,
I got to go back to Dr. McDonough in a minute.
It's reason why. I mean, it's kind of a moving target with what he wants, because again, he'll say one thing and then he'll say something else. The issue as it relates to that's just.
Well, I'm here on this lawsuit.
And again, this lawsuit. I'm only talking about this lawsuit because that's the only one.
So we've got June, November, and June of 16, June of 17, and November.
You're right. The only one really that he has an issue with the personal inspection is June of. It's June 2016 and November 2016. I mean, again, it's the.
Well, it's not the only one.
Well, the June 2017 we have it, and again, if there are these documents are in electronic form, we can produce it. That's not an issue. But he hasn't asked for it in electronic format. He's asked for the documents. We produce them in the normal course of how we operate. If you want it in an electronic format, you do a public records request asking for an electronic format. It's that simple. You are correct. So we gave him what he asked for. If he wants more, Dr. McDonough is very articulate. He can ask for it.
So okay, Doctor.
I have 2 points I'd like to bring up, Your Honor. The first one is the law is very clear that you're allowed to inspect the records and where they're located. The law says that it's preferably to inspect them in the room upon which they're located, or in the alternative, in an adjacent room. Whoever's records I want to look at has the right to designate a custodian record to supervise me as I look over this. Everything is on a mainframe, so I do not have to stop Mr. Good or anyone else from using their computer, because his emails can be put up on another computer. That's my first point. The second point that's very important here is of the 3 records requests, they have delayed by 2, 14, and 9 months respectively. Regardless of how we view me being allowed to personally inspect the records, there is no justification for this unreasonable delay. Your Honor, further, I have a record that was authored by the 4th named partner of WSH, Mitchell Bierman, where he had filed a records request himself on a Friday afternoon. He got the records on a Monday afternoon, and he complained that it was unreasonable delay, that he got business records within 1 business day.
Okay, so let me try and break this down into what I think I can do for you today and what I think is a longer study. Number 1 is today I can assess, look, what records do you want? What records have they made available to you? What inspection parameters in terms of location, etc., are appropriate. Then I can do for you. The consequences of the delay, given the fact that, because as I shared with everybody, this was requested for half an hour, and I'm looking at the paperwork, was skeptical, but everybody thought we could do it in half an hour. I'm not really, what consequences are you seeking as a result of, this is a better way to do this, what consequences are you seeking as a result of the delay? Because I agree with you that it's too long.
Yes, ma'am, Your Honor. I would like, let me first state, one of the reasons why I'm filing the request for inspection is because they repeatedly have a pattern of unlawfully and unreasonably delaying me getting my records. So I've used the inspection because that grants me the ability to inspect them at any reasonable time, which is any hours of business hours. I should be able to walk in and inspect right now. If the city clerk or if the PIO is too busy, they can designate someone to allow me to inspect, and they're required to do that under law. And I'm only asking for the inspection because they continue to unreasonably delay me getting my records, Your Honor.
Okay, so what are you said to me that, look, these records were unduly delayed. I think it's hard to argue under the most extreme circumstances that a 9-month delay is reasonable.
But it hasn't been 9 months. That's what I think we'll address.
Well, with regard to the June.
It wasn't 9 months. We have tested.
Okay, well, let's back up then. So then there needs to be a separate hearing on the delay. So what I'm going back to is, I respectfully and fundamentally disagree with you. I don't think there's a right for any private citizen under a records request to be provided access to a municipal employee's direct work computer with somebody simply standing over them. Because I think that's very difficult to monitor and intercede on in terms of what's appropriate for view under the records inspection and what might not be appropriate, or what might implicate the privacy concerns of other citizens or other municipal matters. So I'm trying to figure out a way to do this in a way that carves out and fully respects the public's rights to access to those records, and at the same time respects the privacy issues of other citizens, of the proprietary and private concerns, although I put both those words in quotes because municipal governments work for us, but still, you know, contract negotiations, things like that, that we all agree are outside of what normally everybody should see. There's things like the cone of silence and things like that. So, and as I said, there are things that are just outside the records request that obviously should be outside those parameters. So in trying to craft a solution that respects those competing concerns, recognizing the significant priority that Florida gives to government in the sunshine and its strong public records request. Do you have any question, Doctor, about any area in which you didn't get records, or are you satisfied that you have the records but you also want them in electronic format? So I'm not going to give you that access under supervision to the computers.
Your Honor, I understand the reasonable restrictions, and I want to point out just one of the 3 requests deals with me personally looking at a computer.
Yeah.
And one of the requests,
Which one is that?
I believe it's the 3rd refusal, Your Honor.
That's 619, third request. I know there's been multiple.
Yeah, in another one of the requests that we're litigating here, I received an invoice, the records were ready for pickup. And when I went to the clerk's office, I asked the city clerk, Elizabeth Sewell, if I could personally inspect the records, and she would refuse to allow me to personally inspect the records that they had possession of because I had not made an appointment. And then I asked for an appointment, and she refused to grant me one.
Okay, well, so that's an issue. What do you?
Come on, okay, we're all over this. If you can just indulge me in just 2 minutes, I can really break this down and make it very simple. Okay? June of 2016, he requests documents. Okay, we give him an estimate of $347, which is what would the reasonable cost to produce the documents.
Yeah, it was $18 for documents and 5 hours of research time and some other charge.
It was about $347 with various different charges. That's correct, Your Honor. Okay, he bought that. Okay, that the city had already undertaken the effort to gather up those documents. So when Dr. McDonough's
Never did or did?
the city had already gathered the documents, was ready to give it to him, and waiting for his check. He never gave him the check. He said he just complained about the fee that was unreasonable. So, so subsequent to that, a colleague of his goes ahead and does the same request. At that point, the city had already gathered the documents, so all the city could do is charge $80. So they produced the documents, and Dr. McDonough has those documents because in the other case, that's on appeal right now, guess what they've attached to their appendix? All the documents from that request. He has those documents.
Okay, but counsel, you didn't produce them. You produced them to someone else. You didn't produce them to Dr. McDonough.
We made them available for him, subject to him.
I understand that, but let's be precise in our terminology. You did not produce them to Dr. McDonough. You made them available. You gave him a bill. He didn't pay for them. So Dr. McDonough's records are presumably still sitting someplace in Homestead. You produced them to Jason.
Is that
Jason,
is that 100%?
Thank
Okay.
you.
Okay. That is, I'm just confirming, that is accurate.
Yeah. I mean, I read it. So,
Your Honor,
So that's,
I've also...
wait. So that's number one.
Right. Then we have
I'll give
the,
you a chance when he's
then we have the November 2016 that
Yeah.
seeks in documents related to the PIO statement to Channel 7.
Yeah.
Those documents were produced. Those are actually produced on. Sorry. Yeah, that's the one where he wants to see the computer for Zach Good. Those documents, he made that request in November. Those documents were produced in December of 2016. His issue isn't that we didn't produce the documents. His issue with that November 2016 request is that he wants to personally inspect Zach Good's computer, which we've talked about here today. And then the last request, the third request is mid-June of 2017. And we have those are the documents we physically have right here today. So, we've either made available or produced documents for other requests.
Is there anything that is omitted by virtue of privilege or otherwise?
We're not claiming an exemption we're not withholding any documents on exemption on June 2017, is that correct? Not in June of 2017.
1D1?
On which one? On June 2016, there were some documents that we claimed were exempt. So again, you're seeking bills related to ongoing litigation, so there were some things that were claimed exempt under 11907. We notified Dr. McDonough of that as well.
Okay.
Again, he's not seeking an in-camera inspection on those documents, whether or not it was properly claimed exemption in June of 2016.
Okay, what about this business about needing an appointment?
The documents,
let me put it this way. I don't have a problem with saying you need to have an appointment because municipal employees are busy. However, if an appointment is not offered within a reasonable period of time, and Dr. McDonough is saying that an appointment could not be scheduled. So what's up with that?
You can't pay, Your Honor. You got to pay to look. You got to pay to look at the documents. I mean, you give him. If he pays for the records, we make them available immediately. That's how it works.
Okay, so, Doctor. Okay, anything else you want to add? You've cleared up what you wanted to clear up? Okay.
I think that's finished.
Your Honor, the city clerk did not refuse because I did not pay. The city clerk refused because I did not have an appointment. Also, I have repeatedly contested the billing for that invoice in writing and verbally, which we have video of. There is no right for them to charge me at $204 an hour for attorney time. That is excessive. They're required to bill me at the lowest reasonable rate of a customer that someone who is available to do it can do. Also, in a separate request that's not being litigated, I had filed asking for the contract with the city to see what their billing was. They also unreasonably delayed and took several months to provide me with that. In that contract, it shows they are a flat rate fee, and they charge for excessive time. It's at $125 an hour. I'm not sure how we get from $125 an hour to $204 an hour.
That's not part of the request that he's asked. That's subject here. That's part of his.
Well, but if you're, look, the records themselves were $18.
It's not accurate what he's saying though.
Okay, so here's where I'm at. Because again, today's hearing is trying to make sure you get the documents. You have the documents. When you've given the documents, give them the electronic documents for Zach Good. You want it in electronic format since I'm not going to let you see the video.
Yes, ma'am. If I could add one more thing, Your Honor, really quickly. The records request of Zach Good, they provided records which were not responsive to my request, and they did not provide records which were responsive to my request, which is why I'm asking for a personal inspection.
Okay, well, I don't believe that it's appropriate to say you can, under supervision. I know that you're asking under supervision. I don't think it's reasonable to allow direct access to an employee computer. I'm happy to have the defendant provide the documents in terms of the metadata and so on and so forth. If you don't think that they're responsive, then that is an in-camera inspection. I can't, because I don't know whether they're saying they are, you're saying they're not.
In Your Honor, with respect to the request directed towards Zach Good, if he provides me with the records, documents, emails, whatever, where he got the false and defamatory statement he made against me and another activist, if I'm provided with that, I would withdraw the request 100%. I just want to know who is telling the city's public information officer false and defamatory things about me to be published in the media.
Okay. Well, that's a question, right? 11, something about 11 times something. I don't remember what it was.
Okay, I'm sure, Your Honor, that the public information officer is not the one who discovered that information.
Whatever it is, give him, you've already said, we've given him what's responsive, right? So either there's a basis for what he shared with Channel 7, whatever it was, or what you've given to him does not have any basis for saying what he said to Channel 7. I don't know which one it is. And that's not before me today, but just make sure that you've provided him with the information that he needs. I want you to give it to him in an electronic format, okay? I'm denying the request to directly access the computer under supervision as being not a reasonable public access request. Did you only need that on Zach Good's computer?
Yes, ma'am. Other than that, I'm not interested. And if I could add just one thing, the law is fairly clear. Normally, if you have a problem with one request, they issue a mandamus. But if there's a pattern and you could reasonably expect that future violations would occur, then an injunction is required, and I would respect the request and if them to be enjoined, Your Honor.
Well, so I think that for the injunction to proceed, I think because there's requirements for injunction, there's requirements for mandamus. So for that, there needs to be an evidentiary hearing, and you need to lay out for me, and look, you know you went around the courthouse, it's evidence, so, you know, give credit where credit's due. I think you need to lay out because this is why I came in here saying, tell me exactly what you want from me. So I think you need to move for either mandamus or an injunction, directing and saying, look, this is what I'm asking for, right? Cameras, no cameras, you know, access within X hours, whatever it is that you want in terms of this going forward, so that we can solve these problems. The court can look at them, determine what they think generally is reasonable, and we'll go from there. Now, hang on one second.
If I could real quick, Your Honor?
Yeah. Because then we'll take evidence on what does or doesn't work.
I would be happy to go back through this and clean it up for you. I was kind of under a delay, and I believe I could possibly file at least 70 legitimate, non-frivolous 119 complaints, but in an effort of judicial economy and compact prosecution, I kept to this sole one. The only reason I'm back here again, Your Honor, is because after they lost in court the last time, and the court determined they unlawfully refused to provide me records, then negative media attention, they continue to disallow me my rights in the public records.
That's what I'm saying. I think we should lay out what you're looking for is, because you're asserting that there's this ongoing, every time you have to fight this fight all over again, what we're going to try and lay out, and what you're seeking from this court is the rules of the road, then let's lay them out. Let's have a hearing, let's take evidence, and let's lay out what's going to happen when Dr. McDonough comes to Homestead asking for records. Because, you know, clearly, this is not infrequent. It's not abusive. I'm not saying it's abusive. I'm just saying it's not infrequent. You're interested in the activities in Homestead. And so I think that that's a better way to proceed. So we've got, everybody's on notice exactly what you're asking for. They can take their position about what they are willing and aren't willing to do, and they can have their evidence brought to court if we can have a hearing on it now. So I'm looking at this bill though. What was redacted?
Your Honor, my partner says that's going to handle that, so he'll talk to that.
Okay, what was redacted?
Your Honor, there are bills that were redacted within there, but the time spent was mostly spent, as far as I reviewed, dealing with things that were withheld based on financial. There were, the original IT search produced back over 2,500 hits that need to be reviewed and narrowed down to what would be responsive. There are about 400, 500 records that were responsive. You're talking about the June 2016 request. There are about 500 records that were responsive. I think there was about 140 or so pages that were produced to Dr. McDonough. There's another 200 or so pages that were withheld based on multiple exemptions. Risk management claims file exemption, insurance claim negotiation exemption, as well as 119071, but those weren't withheld, those were just redacted within what was produced.
So the documents that were produced in June 2016 were produced by electronic record search?
He asked for all records related to the city's defense of Officer McDonough, which included all correspondence between the city and our firm, everything internally. So in order to ensure that everything was captured, IT for the city did a search of the server.
Right.
it was returned 2,500 because of the search terms being as broad as Morito, Stetton.
Right, right.
It produced a lot of stuff that was not responsive to the request. It had to be reviewed to narrow to what was responsive, and then what was responsive had to be reviewed to determine what was exempt and what was confidential. And
So was that the lawyer review?
the lawyer review was only billed 30 minutes of time.
Was that review handled by the
The
lawyer?
last review was handled by the attorney, by our firm with respect to determining what was confidential and what was not. And he was
What
billed
was-
only 30 minutes of that time.
Right. What was the 5 hours of staff time?
That initial part of it, the IT time to
Really?
search
Because I
and-
can use search terms on my computer in about 30
Right, and
seconds.
so Your Honor, as I explained, it went from 2,500 documents to narrow down to 400 or so pages because the search terms return hits of things that are not responsive to the request. They have to be reviewed to eliminate the things that aren't responsive. There are many things that get returned on the server related to Officer Morguido that have nothing to do with White Sorota's or the city's defense of Officer Morguido in the lawsuit that was filed by Dr. McDonough. So there are some 2,000 records that return in the IT search that.
Okay, so what that tells me is you're billing him for too broad of an IT search by your people.
Search based on.
No,
Yeah.
it's based on the search parameters that are provided in his request. If there's a.
No, his request was pretty specific. And I understand you want to be broad. Look, it's always a mixed bag, right? Because government wants to be responsive, and you don't want to overlook anything that would theoretically be due to it. But I'm just saying, the end product of this was $18.30 of documents.
Well, because that was
You're
18
charging him, I can't even do the math in my head, but like a couple $1,000% more than that. I get doing the review, I get doing the research, because specifically this has to do with the conduct of another piece of litigation. I understand that, it's responsible, it's appropriate. What I'm struggling with is saying, you guys got into a fight over this bill, and you didn't get these records over this bill, when the vast majority of this bill, $224 of it, was for research time that was based on the search terms that you guys, he didn't write the search terms, you guys wrote the search terms.
Your Honor, I mean, if we need to have someone come in and testify from IT and from the city to explain that process and provide Your Honor with testimony regarding it, we can do that. I can tell you that that's the time that was passed along. In fact, I think it probably...
Is that the routine hourly rate?
Yes.
Okay.
Yes. There was
So
nothing
that's
that
what
was...
Homestead always charges an insurance request for searches.
For IT time, yes. And...
Well, they didn't spend 5 hours, IT didn't do the report.
No, but there's multiple levels
Right,
of the
but
search
let
that had to be done.
let me finish
Sure,
for purposes of our record. IT did not review to determine whether a hit was because Guido was requesting sick leave to take his dog to the vet versus something that would be responsive.
That is correct, Your Honor.
Correct? IT did not do that.
That's right, that's the clerk office staff that...
Okay, so the clerk office staff hourly rate is what?
Your Honor, I'm sorry, I don't have that off the top of my head.
Okay,
It's
so
generally
what-
around 20, Your Honor. It's generally around $20 per hour. Sometimes it can be upward minus a few dollars.
So one of the things that I think is important is I think you need to provide, file with the court, a list of the hourly rates for record inspections, for record production, public record response charges. Because I'm looking at $45 an hour, which is basically a low-end paralegal rate, and for 5 hours. You're telling me that IT ran the search terms. So that's one thing. Basically, somebody writes down the search terms and gives them to the IT guy. And the IT guy, the IT department runs the search. Then there is a clerical function of somebody going through there and saying, this is Guido taking his dog to the vet. That's not responsive. What level of person is conducting that? Sift, for lack of a better word. Then you get to the sophisticated end that the lawyers do. That's fine. That's billed separately. So when we come back to a sift of getting down to 122 records, but we're charging $310 to find the $18 worth of records, then we get into a reasonableness question. So here's where I'm at. I'm going to set over for further evidence the delay parameters. Doctor, you should set forth a request for an injunction or a motion for injunction. It needs to be supported by an affidavit, please. The rule in question is 1.610. The procedures may be different under a mandamus. I don't have that memorized, so I'm not going to quote you anything on that chapter and verse. At this time, I'm going to direct the City of Homestead to provide the electronic data for the Zach Good request within 20 days. Let me just give it if you want faster.
I'll lay it faster, but I just want to
10
clarify.
days?
I'm not sure if the records I'm looking for are electronic or if it was a memo that was handed to them by the city manager. I had no idea.
They've given you the paper records, they say.
They're not responsive to what I requested.
Well, they may be completely responsive to your request and it just doesn't exist. So they're taking the position they've given you the responsive records.
And the reason I would think that that would be incorrect is normally when you write a letter, you don't put yourself in quotations. And I doubt that the public information officer would go and research the records to see what my lawsuits are.
I can't force people to change their answers. I can just try and get you the answers.
I understand.
Okay? So you want an electronic format that you do?
If they have it, I would prefer that.
Yeah, so 10 days for the electronic formats from the Zach Good production. You got the June of 16 production. They're going to hand you in my presence the June of 2017 production. You're going to file a motion for injunction. We'll set a separate hearing on delay going forward and on the reasonableness of the charge of $347. Now, did he get the $347 records or not?
I'm sorry, Your Honor?
Did he get, were those records that were given to him?
Those records were produced to
Jason.
the other gentleman that made the
Jason.
request.
So
And
you got
Dr.
them back
McDonough
over there.
did receive them, yes.
Right. Okay, so do I need to have a hearing on the $347 or we can take that up as part of the injunction as what are the?
We can have this part of the injunction for unreasonable cost, but what I would like to point out in that, Your Honor, now, the records they produced to Jason consisted of 2 sets of documents of the 122 pages. One of them was a couple of emails, which is very few records.
Yeah.
The overwhelming majority was financials that were WSH's financials. If an attorney can review 122 pages of documents in 1 hour or less, I am completely perplexed how it took an IT specialist 5 hours to find 2 emails.
Well, I'm sure that I will be illuminated or the successor judge because there may be another judge who hears this. But that's the court's ruling for today. We're in past time. I got a zillion people waiting out in the hall, so no.
Your Honor, just real quick, and also regarding the motion to dismiss as to Weiss Sirota, and they haven't served Mr. Zeskind or Mr. Stead. Is that something?
Unfortunately, I will say this. I contacted everybody and said, look, a half an hour, I think my technical words are you kidding me? And everybody said, no, a half an hour. We're at 45. I'm not going to make people wait. This is going to have to be taken up at the next hearing on this.
I would ask people that in advance when they're properly served and brought into jurisdiction of court, Your Honor.
Well, Weiss Sirota was served, not.
No, we're the 2 attorneys, Stetton, that's
Yeah,
fine.
well, there's no remedy against them at this point.
That's fine.
I'm not
Okay.
pursuing anything.
Okay, that's fine.
Okay.
Thank you so much, Your Honor. God bless.
Thanks. So, we going to have a debate about the language of the order? Because if we are, go ahead and get a blank and write it up here now.
I think, Your Honor, given the history between Dr. McDonough and the city, that we should draft the order. We'll draft it outside the presence and we'll bring it back to you.
Perfect, because I will be in here being busy.
That's it.
Michael, can you give him a blank, give them a, please? Just give him a couple
I have a
blanks.
blank order I can fill out.
I like mine. Okay? And Marissa, would you be so kind as to ask the assembly clerks outside and set them? Yes.
Again, thank you so much, Your Honor.
Thanks.
There you go.
Thank you, sir.